Hey everybody, we're just welcome. We're just going to have a minute or so waiting for people to come into the call. Right. Okay, we might get started this morning. I know we've got a lot to get through, but good morning to those who've joined us so far and welcome to Giants Weekly. I'd like to first begin by acknowledging the traditional owners of the land upon which we meet. We pay our respects to the elders, past, present, and emerging, and we acknowledge their spiritual connection to country. My name is Melia. I'm part of the community team here at Blackbird, and thanks for joining us today for Giants Weekly. This morning, we're joined by Shaun Restorick-Barton, a corporate lawyer at Law Squared. Shaun is going to take us through all the essentials in setting up your startup from a legal perspective, ensuring that you and your team are protected and operating within the Australian legal framework. As usual, we're launching straight into Shaun's presentation, so let me know if you have any questions using the Zoom Q&A function, and we'll have about 10 minutes at the end for them to be answered. Over to you, Shaun.
Cool. Good morning. Thank you for the introduction, and thank you for those attending. I can't see you, but I'm sure there's plenty of you there for such an interesting and often not sexy topic, but really important for early stage founders, and something that we find by the time they come to us, often some of these things have been missed or skipped or overlooked, and then it becomes a bit more of a challenge to be super helpful. So the first thing we're going to look at, here's the agenda, but the first thing we're going to look at, I'm going to have to rush through a few of these, but we can touch base back on them during questions, is business plan structures, equity, important contracts for the business. And if we get time, we'll have a quick look at brand protection and IP. So business plan's not really a legal point, but it's a really important process we find to not only road test your idea and to build out a timetable for how you're going to progress through, validation, customer inquiries, and then look to develop a framework or wireframes or start doing a tech build, whatever it might be that you're moving into. But it's a good time to actually really dig deep into the market that you're moving into and to start to understand if there are any regulatory issues around the area within which you want to play. So for example, you're rolling out a fintech product, then you might need to think about, well, are there securities, are there banking or credit laws that I need to be aware of, or regulations that I need to understand that could be a massive hurdle or at least a speed bump in getting some product to market. Another big one that we find that happens a lot is if you've got a data play business, if you're looking to have some kind of aggregated and commercialized data, is there an issue, or is there some considerations you need to have about consumer data breaches or privacy issues? And your technology will often then need to be built around following some of those regulations. And we see it happen, the data piece we see happen quite a lot with clients. When you're agreeing to working with a bank, for example, you need to make sure that you can comply with whatever their privacy and data obligations are as well. Going into structures, now structures are super important because not only does it determine, as we say here, your risk exposure, your legal and financial obligations, it also gives you a framework or a foundation within which you can then build your business. So if you are looking at scaling really rapidly and you're looking to take on external investment, then a trust, for example, that you trade through is probably not the best structure. Once you've put some of these things into play, and here are 5 obvious ones, but once you've put some of these things into play, it is a bit of a pain and sometimes a cost to go back and try and rejig that structure or start from something new And there can be tax obligations and problems that can pop up if you try and then make a change after you've set everything up. So these are the 5 most common. I will ignore the first one and the last 2, only because for the purposes of the type of businesses I'm sure most of you are looking to set up, they're probably not the right structure. A sole trader is great when you're road testing a product and you're doing some customer validation and you're not yet ready to build product and launch to the market, but you're just in a beta testing phase. But really, once you start getting serious, then you're going to want to look to put some kind of formal structure around it. And more often than not, that's a private company. So that's your PTY Ltd. Social enterprise is something that we see is growing quite rapidly. There's a lot of social funds that are looking to invest in this space, and there's a lot of impetus, I guess, from consumers around what is a socially responsible or a good business that I want to give my money to that has some kind of mission. There's also a movement around in Australia in growing the B Corp space. So it is an area that's ripe for growth. There are a whole bunch of different variations within the idea of a social enterprise, from your traditional charity, not-for-profit, all the way up to a business that is socially conscious but for profit. And we see quite a lot of those popping up. So that's where that B Corp space starts to come into play. And if it's an area you're interested in, I would recommend having a look at some of those B Corp examples that you might find online and just get an understanding of how they operate. Because as a consumer, it is an area where you might want to spend your money with a little bit more thought around the type of business that you're giving that cash to. These are the 4 main areas for a charity social enterprise: company limited by guarantee, incorporated association, a charitable trust, and then that for-purpose but for-profit company, which is where most of the new social enterprises we see will fall into. So they're allowed to make a profit, they're allowed to make money, but they do it for a good social conscious reason. It's really important to be super clear about your vision and plan out your structure before you really start registering companies and putting things in place. It's good to, obviously, I'm going to say this, but it's good to seek legal and accounting advice, not just for the now, but to work out what is the strategic plan for how you might scale. And some of those structural bases that you put in place will help you more quickly scale into different jurisdictions or take on investment, bring on external partners or bring on other founders, and things like collaboration and joint venturing with other businesses, with other technology providers. Some of those structures, like a company, are far more versatile when you're looking to put that in place. And then obviously assessing your liability and risk exposures. You know, a company, instead of a sole trader, for example, a company is its own legal entity. So when someone signs up to deal with a company, that's who they deal with. They don't deal with the individual directors behind that company. So there is a layer of protection for the founders who sit behind that company as the directors. Now, this is a massive one, and this is one that we see the most activity as lawyers, typically in the positive side on the front end, but also in the negative side when people start having discussions and disputes and arguments about equity. So, you know, obviously co-founders working together, it's really important to have balance and understanding about how you manage equity, but it's also important to not start being frivolous with that equity and giving it away when you might not necessarily need to. So we see a lot of early stage startups, you know, providing equity to service providers because they might not have the capital or the cash at the beginning to pay for those services. And we understand that cash is a struggle when you're an early stage founder, but the challenges and the difficulties that can arise in the future if you start giving away equity, you know, to a graphic designer or, you know, a developer who's doing a small piece of work for you at the very early stage that might be worth 5 or 10 grand. That can become a bigger issue as you grow and you go to raise investment, because you've then got people sitting on your cap table that might no longer be interested in the business, might not have the same ideas around what their value was at the beginning, and it can cause some challenges and some problems. And I'm sure Melia would be able to comment that she would see from the investment side or from the fund side that, you know, if you've got a messy cap table when you come to do a Series A or a seed investment round, and you've got a whole bunch of random people sitting on your cap table, it can be a bit of a red flag, because, you know, the fund coming in goes, well, these are all people that we don't know, that we don't understand the relationship within the business, and we might have to deal with when it comes to making some really big decisions for this company. And so that can raise some real concern. Also, if those relationships become tarnished, you then have toxicity sitting on the cap table that you don't necessarily need to have in your life or in your business when you go to make those big decisions. So this is that sweat equity component that I talk about. You know, you can have sweat equity within the business for employees, for example, but, you know, it's something we don't have time to really talk about today. But if you do have equity coming out to employees or contractors within the business, you really should have some structure around how that's managed. So as you grow, you will hear talk about employee share option plans or employee share plans. These are things you can start, again, building some structure around, having a think around what the timing looks like for you and how that will affect your business. Because no doubt by the time you come to raise capital, a sophisticated investor will have those questions for you. And it would be good to have an answer for them, or at least a framework to say, well, we don't have it now, but we're looking to allocate, for example, 10% of our current, you know, fully diluted capital as a pool of options that we might then use to incentivize staff or bring on key hires. You know, it's something that shows maturity as a founder, and it shows that you've got the forethought to say, well, these are things that an investor might expect to see. So let's get that in place. Also, it's good, you know, as a way of incentivizing staff, building loyalty, having skin in the game, so long as you put thought around how you might manage and control that equity. So that's things like vesting, which we'll touch upon briefly. So if you're not familiar with the concept of vesting, the easiest way for us to explain it is locking up equity subject to some milestones, KPIs, timelines that say, well, you get the right to keep that equity and enjoy the benefits of it so long as you do these things. And that might be stay within the company for a period of time, that might be hitting some KPIs or ticking off some certain milestones. The benefit of this is that whilst, yes, someone has that equity, they can't sell it, sometimes they can't vote on it, they can't receive a dividend on it. And that means that they then have an incentive again to stay in the business and do things to help the business grow and you know, to really make sure that when they receive the benefit of the equity, it's because they worked hard to make sure that the company receives the benefit of their efforts and their time. It also means that if they were to leave on good or bad terms, depending on how your documents are prepared, it means that the company has some rights around how they then deal with those shares. So that could be buying them back. If they're not vested fully, they can buy them back for typically $1. If they are vested and they leave, sometimes they can still buy them back, but they buy them back for a reasonable, you know, fair market price. So you're then bringing that person off the cap table. Yes, you're giving them some cash, a liquidation event, if you will, but it means that there's a voting percentage that you've brought back on the table. There's dilution that you've managed. And it might mean that the founders, you know, buy some of that equity themselves so that they can increase their equity holding that prevents some additional dilution for them going forward. So there are various ways that you can skin that cap, but it's really important to have a think about it, put a framework around it, and don't just start flippantly giving away equity or issuing out shares, because you've got to think about not what it means for you now, but what it means for you in 6 months, 12 months, or, you know, a Series A, Series B, Series C. Because founders who have 5% of their company when they raise a Series A are probably not going to be the most incentivized founders to grow an amazing business with $1 million in the bank than someone who might have 20 or 30% of their company. And if you give away that early stage equity before you need to, it means that you've got less when it comes to, you know, the really exciting part when your business is on that fancy part of the hockey stick where you're going straight up, or you're moving into new jurisdictions. So share options, I think I've touched on that enough for the purposes of time. We've got about 5 minutes left. So we'll skip through this option plan. We've talked about that. Let's go to important contracts. So Founders Agreement, very briefly, I'm sure you're all familiar with it, but it's really important if you don't have a Founders Agreement to at least have the discussions that would form what would be in that document. So have the hard conversations as early as you can. What is my role? What is my responsibility? What am I accountable for within this business? What is my expectation around what I'm going to get from the company as a founder? What am I willing to give back? So what's my time commitment? Is there a capital investment commitment? Am I happy to take no salary for 12 months? All of these things, all of the awkward, weird, tough conversations around money and expectations and equity, have them as early as you can, because these are the things that we sadly see cause the most disputes once there's money in the bank, or the business starts making revenue, or investors start coming along. Or if someone, things that aren't negative, someone has a family, or someone, well, it is negative, but not by their own action. Someone gets unwell, or someone gets a great opportunity to go and work in another company. These are all things that will have an effect on their ability to work within the business. And if they've already got half the equity, then that can make things challenging. So have a think about how you would manage that, and have those conversations. Record as much as you can, in a plan, in the business plan, in some kind of document that doesn't necessarily need to be a formal contract. It can be, but at least it puts some framework around your discussions, and something you can refer back to, and again, like I say, hold each other accountable. Now, a shareholders agreement, this is for us one of the most critical documents you'll ever have in your business, because it manages the relationship between founders, directors, and shareholders, but also what happens when you want to raise capital, what happens when someone wants to leave the business, what happens when you've got to make some massive decisions within the company, who makes those decisions, and how many of them have to agree for that resolution to pass. So having a really good shareholders agreement in place, we think is fundamental if you're going to grow a good business. Timing wise, it really depends. Some people don't put one in place until they're about to raise capital. Some people put one in place as soon as they issue equity out to a person that's not a founder. Some people put one in place when it's just two founders. So, that comes down to when you're having discussions with some advisors, whether it's lawyers or other founders or people within your network. So you determine the timing based on where your relationships sit and how comfortable you are with the risk of not having it. But it is critical to put it in place and to really engage with the document. Don't just ask someone to prepare one and then not look at it. Really work through what is in the doc and why is it in the document, and what are the variations of those terms, because we see a lot of people just take a shareholders agreement off the shelf, not really read it, enter in their details, sign it, and then put it in a drawer. And sadly, when things are going great, that's fine. You never need to look at it. But when things are not so great and you pull it out and you realize it doesn't do any of the things you need it to do, that's when things become really difficult, because when you've got ambiguity, there's room for interpretation, and then there's room to have a fight about it. And some lawyers might love that because it gives them heaps of work and heaps of business, but there's nothing sadder than seeing a really amazing business falling apart because it doesn't have the mechanics in place to deal with a founder dispute, for example, or someone wanting to leave and being able to take 40% of the equity off the table. So have a really good think about how you're going to manage that process, but it's so important to do it properly and to just engage with someone to help you. Cool, we made it to brand protection IP and we've got about a minute. So really important with IP is to work out exactly what is IP within your business. Protect it as best you can early. So that can mean using NDAs when you're talking with potential partners, with potential investors. Is an interesting, there's a discussion for another day around whether you should give an investor an NDA, and maybe talk to the Blackbird folks about that first. But especially people that you're talking to who are going to help you grow your business, develop your product, or collaborate with you. So that's where an NDA can be really important. Confidentiality terms should be in all of your contracting documents. So employees, contractors, devs, advisors, all of that stuff, have some terms around confidentiality and protection of IP, and also ownership of IP in those contracts is hypercritical. If I'm paying a dev to build something for me, I should own that outcome. I shouldn't get a license for it. And that is super important. So make sure that you put some thoughts around that, and make sure that you get some guidance and protect it as best you can. And look, we whipped through, but I think we just made it. So feel free to bombard me with questions, but thank you so much for your time and attention. Take a breath now.
Wow, how about that time integrity? Amazing work, Shaun. Thanks for sharing such in-depth slides and information with us. And for those wondering, as I'm sure people are, we will record this and share this presentation, so you can go back and look through some of his points.
At half speed.
At half speed, exactly. To kick off the Q&A, we've got a question on dual company structures in the early stages and your thoughts on that. So for instance, if the IP is owned by a parent company and the employees are hired through a subsidiary, do you have any advice or thoughts on that structure?
Yeah, absolutely. We see that happen a lot, and it's good to have those conversations around multi-entity structures with lawyers and accountants involved, because there's some good collaboration and compromise that you balance out on tax versus risk. But we see it a lot. We see IP held separate to the employees, separate to the customers, and sometimes separate from the investors. So you've got a 3-entity structure with an ultimate holding company at the top, separate IP and separate trading. And the reasons behind that is because then you're isolating the intellectual property, which arguably is where all your value is at the early stage, away from where all your risks sit. So all of your human-based relationships are separate to your IP. And you typically have a license in place between IP and trading companies. That way, if something goes wrong with a client or with a relationship that's using your product, and someone sadly tries to sue the trading company, that company can be shut down arguably because it's of zero value. It can absorb all of that risk and all of that negativity, but your IP is separate. The license can be terminated and the intellectual property can be used again and is in an isolated vessel that's not owned by or controlled by that trading company. So it is a good idea. It is additional cost. But often we say, think about what is a trigger point for making a call around whether you're going to split it out. And it could be if you've got a very risky business model, it's before you go to clients, or it could be when you hit 50 clients or a certain amount of revenue. So, these are things that accountants and lawyers can guide you on, but it can be really worthwhile and can be really useful. But it's just important to make sure if you're going to do that, do it properly, because the tax position can be a real pain, because if you try and fix it after, you might be transferring valuable IP assets and you might have to pay tax on those, even if you're only moving it from one company you control to another.
Great, thank you. Next question, how does the shareholders agreement interact with the company constitution?
Yeah, so usually company constitutions are the most vanilla company governance documents that businesses will have, because they usually get it when they go to ClearDocs online or shelf.com and download their company register, and it comes with a really basic constitution. The shareholders agreement supersedes in most cases any terms that are conflicted or ambiguous between the shareholders and the constitution, because this shareholders agreement is normally newer. It involves more engagement and more involvement and more advice and drafting. So often lawyers will put a term in a shareholders agreement to say that this document will always supersede the constitution if there is any conflict or ambiguity between the two. But what we often will say is, when you're going through the process of preparing a really nice shareholders agreement that's bespoke or made to measure for your company, look to maybe replace your constitution with something that better reflects and talks to the shareholders agreement, because the constitution, more often than not, is a document that was prepared 20 years ago and is just a template that either an online provider or an accountant sometimes will even provide a generic constitution to you. So they're not always great documents, and more often than not, they're pretty process and administrative only. There's nothing really special or creative for you to benefit from the way that a shareholders agreement will be used. Great.
Question on buying back unvested shares. So regarding buying back unvested shares at cost price, do you have any advice on what can determine cost price? So for instance, the share already has an existing price. Would that determine the cost price, or is there a different way to go about that?
Well, with the unvested shares, usually whatever contract you've got, whether it's an ESOP or an employee share scheme, or even sometimes shareholders agreements will have those buyback mechanisms for vesting in. Normally that will determine that an unvested share or all unvested shares are bought back for a collective price of $1. So that document determined, or that clause determines what the purchase price is for those shares. When we're talking about vested shares, that's a different concept. So that's when we're talking about potentially ideals around good leaver or bad leaver provisions. So if you leave on bad terms, and those terms are usually pretty bad, it's not just I had a change of heart and I've gone elsewhere. It's, I breached company policy. I was, summarily terminated for beating someone up in the office, whatever it might be. That's when we talk about fair market value and a discount applied to fair market value. So if you leave as a good leaver, often what they'll say is they'll pay fair market, which might have a metric involved or a method involved in how you work that out. You might get a valuation, or it might be that the board determines reasonably what fair market is. And then if you're a bad leaver, they might apply a discount. And that discount I've seen range from 90%, which I think is insane, through to like 20, 30%, which is probably more common and probably a bit more reasonable.
Cool. We have a couple of questions around international elements, I suppose. So full disclosure, Shaun, if this is outside your remit, please
yeah, I definitely will let you know.
Well, one question is around a founder who's in the early stages of building an online marketplace where suppliers are coming from one country and buyers are in another. And their question was, how should they be thinking about terms of use on their website, and what legal requirements they kind of need to satisfy in the public facing sense?
Yeah, I mean, terms and conditions are, and we didn't have time to touch upon it, but they are probably, we've talked about all the internal management documents, but as an external document, that is probably going to be your next most important document, because it manages your relationship with your customers, or in this instance, your suppliers as well. So if you're building a dual-sided marketplace, typically our terms, or the terms and conditions, are designed to try and lift as much legal responsibility from the platform provider, being you, as humanly possible, because really you're facilitating a transaction between two people you have no control over. So often, if you've got just a platform where you're creating this dual-sided marketplace and you can't manage that relationship, it won't matter where the seller is or where the buyer is, because your terms should be drafted to exclude as much liability and responsibility for you as humanly possible, like I said. If you are involved in the supplier relationship, and they are international suppliers and they are larger, more often than not, you might actually have to have separate merchant terms with that particular supplier to govern that relationship. And that's where you will deal with things like warranties, if there's a recall, if there's a problem with the product, if there's a customer complaint, and how you manage that relationship. So it's difficult for me to kind of hypothesize what would be in that, but you're either going to exclude all responsibility, or you are going to try and manage that individual relationship with some of those larger international suppliers on a case-by-case basis. But great question. It is a tricky one to navigate.
Absolutely. Now, I know we're running out of time. I want to just try and squeeze in two more questions if possible.
Yeah, of course.
First one is on any advice for approaching incorporation in the US and Europe. So just a small question.
Damn. Get really good advice. We collaborate with, some large multinational sort of finance tax advisory organizations. I won't name names in case there's existing relationships within the Blackbird network, but there are big things to consider. There's stuff like transfer pricing and tax regimes, and different countries have different tax relationships with Australia that benefit you or are negative to you. So before you start rushing into different international markets, get as much of that advice as you can possibly get, and it can be really expensive. So that will affect your ability to move internationally with the right guidance. But it is so important, because we've had clients who are in the retail space, for example, and have a distribution model where product is manufactured in China and they wanted to distribute out of Hong Kong. That had crazy tax implications for them just by opening boxes in Hong Kong. And it sounds so mundane and ridiculous that exists, but these are the way that these relationships work around the world with tax. So it's so important to get a good base and understanding and advice around how to do it. Can't talk about that enough.